Hello everyone, my name is Thuy Chan, and the topic that my group choosing to do is the right to privacy. Specifically in my part is contraception, and the court case will be Griswold versus Connecticut. First to start, I would like to talk about the constitutional right. The right to privacy is most often cited in the Due Process Clause of the 14th Amendment, which states, "No state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law." And in the case of Griswold versus Connecticut in 1965, in 1879, Barnum, serving as a Connecticut state senator, introduced a bill prohibiting the distribution of information on contraception and abortion, and the use of any drug, medicine, article, or instrument for the purpose of preventing conception. The Great Showman Bill passed, becoming among the most restrictive birth control laws in the United States. Under the Barnum Act, married couples face arrest and imprisonment for using birth control. In the pictures on the left is Esther Griswold, a medical advisor and executive director of the Planned Parenthood Clinic in New Haven. In 1960, the United States Food and Drug Administration approved the first oral contraceptive, making safe, effective birth control available, but not in Connecticut. The following year, Esther Griswold and C. Lee Buston, the chair of the Yale Medical School Department of Obstetrics and Gynecology and a volunteer with the PPLC, decided to challenge the Barnum Act in court. And the Supreme Court decision is, on June 7, 1965, the court voted 7-2 to strike down the Connecticut law. They ruled the Barnum Act unconstitutional and that an individual right to privacy was a fundamental right that could not be infringed upon by the state. While this initial decision applied only to married couples, in 1972, the court extended the same protection to unmarried couples. The result is the Supreme Court ruling in Griswold versus Connecticut marked the beginning of an era of change for sexual and reproductive rights in the United States. And this is also the first recognize the right to privacy based on this case. And here's my was cited page. Thank you.
In this presentation, I will be going over the court case of Lawrence versus Texas and how this landmark case pertains to the American concept of our right to privacy. So, what was Lawrence versus Texas? It was a 2003 landmark decision of the U.S. Supreme Court regarding the punishment for those who commit the act of sodomy. This case was actually similar to a previous case called Roe versus Wade, where the idea of a right to privacy was fully considered. Even though the idea of a right to privacy is not explicitly stated in the U.S. Constitution, it was based off of a combination of rules from different amendments, which I will get to in a second. So, what exactly does it mean to have a right to privacy? Well, this idea of a right to privacy is based off of the 1965 court case of Griswold versus Connecticut, where it was established that couples have a right to privacy in terms of keeping certain matters in the relationship private from others. However, at the time, this only pertained to married couples of a man and woman. After the ruling of Lawrence versus Texas case, however, we will see that that viewpoint had begun to change, as I will get into in the next slide. So now, in terms of amendments, the right to privacy comes from the Fourth Amendment's protection of private homes from searches and seizures without a warrant based on probable cause, the 14th Amendment's guarantee of due process of law in the states, and the Ninth Amendment's assurance that rights not specifically stated in the Constitution are retained by the people. So, after carefully considering the Fourth, Ninth, and 14th Amendments, the term right to privacy was justified in a lawful manner. So, moving on, what was the final ruling of this case? Well, the court decided that penalties of criminal punishment for those who commit sodomy was completely unconstitutional. The court based its ruling on the idea of personal freedom to define one's own relationships and of American traditions of non interference with private sexual decisions between two consenting adults. After this ruling, any and all law pertaining to sodomy in Texas was completely removed in a 6-3 decision. In effect, sodomy law was removed in 13 other states, making same sex sexual activity legal in all 50 states of America. The court held that intimate consensual sexual conduct was part of the liberty protected under the Due Process Clause of the 14th Amendment to the U.S. Constitution. The Lawrence versus Texas case completely abolished similar laws throughout the United States that criminalize sodomy between consenting adults acting in private, no matter the sex of the adults. So, what is the conclusion? What can we make out of this? Well, in the end of the Lawrence versus Texas landmark case of 2003, it made a large impact on what is accepted here in America, and it also expanded upon the rights of Americans in regards to private matters in their lives. Even though it is not explicitly stated, protections are provided by the amendments.
Hello everybody, I'm Enmi and I will be talking about the Whole Woman's Health versus Herstead case. So to give you a little background on the case, I would like to talk about the Roe versus Wade case that took place in 1973. The Supreme Court ruled that the Constitution of the United States protects a pregnant woman's liberty to choose to have an abortion without excessive government restriction. Another case that took place regarding abortion was the Planned Parenthood of Southeastern Pennsylvania versus Casey, which took place in 1992. The ruling of this case reaffirmed Roe versus Wade's right to abortion, and it permitted restrictions on abortion as long as they do not impose undue burden on the patient. Undue burden means to place a substantial obstacle in the path of someone seeking an abortion. Now, to get into the Whole Woman's Health versus Hellerstedt case, which took place in 2016. Texas began passing restrictions against abortion in 2013. One restriction was for the doctors to get admitting privileges, which were not easy to obtain. Another restriction was for clinics required to have costly hospital-grade facilities. Before these restrictions were passed, there were 39 abortion providers in Texas. After the restrictions were passed, only 10 were left. Many women were hundreds of miles away from their nearest abortion providers. The case would then be taken to the Supreme Court. The Supreme Court ruled 5-3 that Texas cannot place restrictions on the delivery of abortion services that create an undue burden for women seeking an abortion. The undue burden was having these restrictions that caused many clinics to shut down, leaving many women with no abortion providers for hundreds of miles.
Hello, my name is Abraham Garcia, and our group chose to do rights to privacy. My section in particular showcases a court case, Planned Parenthood versus Casey, which is focused on abortion laws. Couple of facts about the case. It was in the year of 1992 in southeastern Pennsylvania, and it started because the Abortion Control Act violated Roe versus Wade, which was decided in the year of 1973. So, in a nutshell, Planned Parenthood wanted to sue Bob Casey Jr. for passing laws that were unconstitutional and violated one of the first abortion cases, which was Roe v. Wade. The Control Act focused on 5 requirements. Number 1 being a woman who is seeking to undergo procedure must give informed consent. In other words, the person getting the procedure done must agree to follow through with it. Number 2. Must be given anti-abortion paperwork, propaganda, 24 hours prior to procedure. So there were many anti-abortion papers given to people who were about to get the procedure done the next day, and most of them were anti-abortion papers. Number 3, women under the age of 18 must have parental consent. That's pretty self-explanatory. Number 4, married woman must inform spouse of intent. So this one right here is one of the main requirements that the court would argue about. They were scared of the husband getting mad or, starting a fight over the spouse trying to, get an abortion, and they were scared of like domestic violence and stuff like that. And number 5, abortion clinics to be more transparent and maintain better records. So basically, the government just wants to be able to see everything they do. In Planned Parenthood versus Casey, there were 9 justices by the name of O'Connor, Kennedy, Souter, Stevens, Blackmun, Thomas, Scalia, White, and Rehnquist. In the beginning, O'Connor, Kennedy, and Souter were the people who were on Planned Parenthood's side during the case. The 3 of them released a joint opinion, which caused Stevens and Blackmun to follow in their footsteps, winning the court case 5-4. Thomas, Scalia, White, and Rehnquist all believed that abortion itself was unconstitutional. But in the end, Planned Parenthood prevailed. So what came from this case? One thing was viability of the fetus, and that's basically addressing the health of the child and if it would live or not. In Roe versus Wade, the number of weeks was much smaller at the time. And at the time of Planned Parenthood versus Casey, it was lifted to 24 weeks due to the advancement in technology. So in a nutshell, they didn't have the right technology to determine the month span or viability of the fetus. And then we have the undue burden standard. And it's basically like a saying that legislature cannot imply a law that is too restrictive of someone's fundamental rights. And here is the key judgment of the case. Under Casey, abortion regulations are valid so long as they do not pose a substantial obstacle and meet the threshold requirement of being reasonably related to a legitimate purpose. That concludes the end of my slideshow, and here is who did what, and we appreciate you for taking the time to listen, and we hope you have a great day. Thank you.